Welcome to the Office of Administrative Hearings Video Guide to Hearings. My name is Eric Lipman, and for the next 8 minutes we will explain some of the basic procedures for cases at the Office of Administrative Hearings and give you details on where you can learn more information. So thanks for tuning in. The Office of Administrative Hearings, or OAH, resolves disputes between members of the public and government agencies. Our job is to assure that government agencies follow the laws that govern their operations. Let's say you've just received a notice of hearing from a state or local agency, like the Minnesota Department of Human Services or the City of Minneapolis. The notice states that a government agency has taken some action, like revoking a license or denying your application for a government benefit. If you thought the agency was wrong and you appealed that decision, the notice of hearing represents the very next step in the appeal process. Be sure to read the notice of hearing very carefully. The notice tells you what the agency thinks the hearing will be about, where proceedings will occur, and when either a hearing or a pre-hearing conference will take place. If a pre-hearing conference is scheduled in your case, this is a time for you, the agency representative, and the administrative law judge all to discuss how and when your case will make its way to a hearing. Also, make sure that you let the agency representative and the administrative law judge know if you're unable to attend either the hearing or the pre-hearing conference. If you simply fail to show up at either the hearing or the pre-hearing conference, you could lose your case by default. A hearing is a process for presenting disputes to a judge. Our hearing process is designed to be open and accessible even for folks who aren't represented by a lawyer. There are just a few simple rules, and if you follow those, the hearing will go smoothly. In the rest of this presentation, we will show you some examples of what a hearing looks like. The judge will tell you who will present their evidence first. Evidence can be in the form of documents, like photographs, receipts, or letters, or what people testify to in the courtroom. You should bring to the hearing any evidence that is helpful to your case. The documents you bring to the hearing are called exhibits. You should have 4 copies of your exhibits. 1 set for you, 1 set for the agency representative, 1 copy for the judge, and 1 copy for use by the witnesses who are called to testify in the case. Let's look at a typical courtroom.
Good morning. Before we get started, have the parties had a chance to exchange exhibits?
Yes, Your Honor. Ms. Jones and the agency have exchanged our exhibits, and we pre-marked them. The agency's exhibits are marked 1 through 10, and Ms. Jones's exhibits are marked A through L.
Ms. Jones, have you had a chance to look at the agency's exhibits?
Yes, I have, Your Honor.
Do you have any objections to the agency's exhibits?
Well, I don't like what some of them say, Your Honor.
Well, I understand that you may disagree with some of the things that are in the documents, and you'll have a chance to tell me about those disagreements later. But what I'm asking you now is there any reason to believe that these documents are not what they purport to be?
No. These are copies of the documents I received from the licensing division. So, I guess I don't have any objections, Your Honor.
Okay. The agency's exhibits 1 through 10 are received. Ms. Jones, would you like to offer your exhibits into evidence?
Yes, Your Honor.
Mr. Smith, do you have any objections to Ms. Jones's exhibits?
The agency has no objections to the exhibits.
Ms. Jones' exhibits A through L are received. Please bring me the marked copy of your marked exhibits. Thank you. Thank you.
In a hearing, there are 2 kinds of questioning. There's direct examination, during which a party may ask questions of someone whom he or she has called to a hearing. There's also cross-examination, during which a party asks questions of another party's witnesses. During direct examination, you cannot ask a question that suggests what you want the answer to be. Here's an example.
Ms. Brown, did you see dangerous chemicals within the reach of daycare children when you inspected Ms. Jones's daycare on September 29th?
I object, Your Honor. He's telling her what to say.
I agree. Your objection is sustained. Mr. Smith, you may not ask leading questions of your witness. This is direct examination.
Yes, Your Honor. I'll rephrase the question. Ms. Brown, when did you last inspect Ms. Jones's daycare?
On September 29th.
And what did you see on that day?
I saw a can of paint remover on a shelf in an unlocked storage room, which was accessible to the daycare children.
When you're cross-examining a witness, you may ask questions that suggest the answer.
Miss Brown, isn't it true that I unlocked the storeroom door during your inspection to get a new battery for the baby monitor?
Yes, but I...
Thank you, Miss Brown. You've answered my question.
It's important to keep your cool at a hearing, even if you disagree with something that a witness has said.
I called Ms. Jones 5 times and left a message on her answering machine each time, telling her that I needed a written response to the correction order.
That's a lie. You never left me any messages.
Ms. Jones, it is not your turn to testify. I will hear from you when the agency is finished. If there is something an agency witness says that you disagree with, make a note for yourself. You'll have a chance to ask them questions. And when it's your turn to present your case, then you can testify and tell what happened.
After each side has presented its evidence, the judge will give each side an opportunity to make closing arguments. Closing arguments are a way to remind the judge of what she's seen and heard about the case. Let's listen to a couple of very short closing arguments.
Your Honor, the agency has demonstrated that Ms. Jones's daycare does not meet the safety standards required for the protection of children. The agency has also shown that Ms. Jones has repeatedly failed to respond to the correction order that was issued to her. For these reasons, the agency requests that you recommend that Ms. Jones's daycare license be revoked. Thank you.
Ms. Jones?
Your Honor, I think that I have shown that these so-called violations are exaggerated. For example, the claim that children had access to dangerous chemicals because I opened a locked storeroom door long enough to get a battery is just plain wrong. There were no children nearby, and I was standing in the doorway the whole time. Why should I lose my daycare license just because I went to get a battery? Thank you, Your Honor.
In most cases, but not all, the judge issues a recommendation to the head of the agency who makes the final decision. The judge will not issue a decision in your case on the day of the hearing. Usually the judge will issue a recommended decision within 30 days of the close of the hearing record. You'll get a copy of the decision in the mail, and along with the decision, you'll also get an explanation of the process for any further appeal. Lastly, we've posted a lot of really useful information on how to prepare for a hearing at the OAH website, www.oah.state.mn.us. We appreciate your time and watching this video and look forward to seeing you soon.